This is Michael Popok, Legal AF After Dark. You like gag orders? We got them in all shapes and sizes as it relates to Donald Trump. We got one up in New York dealing with the gag order placed on Donald Trump and his attorneys by Judge Engoron in the civil fraud case. But the Mac Daddy of all gag order decisions is going to come out of the D.C. Court of Appeals based on Judge Chutkan, the federal judge's limited gag order against Donald Trump to stop him from using violent rhetoric against courtroom participants. Sounds like a great idea. What does the D.C. election three-judge panel think? Well, Karen Friedman Agnifilo in one corner, me, Michael Popok, in the other. We debate it on this most recent episode of Legal AF. Take a listen. Let's move on and hit quickly the appellate argument that was just held by the three-judge panel, randomly selected D.C. Federal Court of Appeals, about the gag order that was entered by Judge Chutkan. What's the common theme here? Donald Trump is out of control, attacking participants in the criminal justice system or the justice system against him, from judges to prosecutors to attorney generals and to witnesses and their families. And the judges are struggling to try to come up with ways to stop it without crossing over into improper prior restraint or violation of a First Amendment rights of somebody who just also happens to be running for the highest office of the land. And that's the needle they have to thread. Or as Judge Millett said during the oral argument, we've got to come up as an appellate court with a surgical way to both protect the fair administration of justice and the Sixth Amendment rights that go with it, to a fair and impartial jury, if you will, and the First Amendment rights of this person who's also a participant in the criminal justice system. All of these, as they kept reminding mainly the lawyer for Donald Trump, arguing, there are competing interests that have to be weighed. Donald Trump doesn't want to weigh a darn thing. He wants to throw away the scale and says, I'm cloaked with the First Amendment. I am super Trump. I get to say and do whatever I please because I'm running for office and people like to listen to me. That is not how the First Amendment, nor the interest, what courts have to do to balance the competing interests. These interests compete. And that's what judges get paid to do. And that was where John Sarro, not to be confused with John Larrow, who's the day-to-day criminal lawyer for Donald Trump, John Sarro, who's a MAGA right-wing lawyer who constantly appears in front of Congress claiming the Biden administration is conspiring against all other people through their social media feeds. I mean, he's nutty too. But, he got up there and right away, his little car went into a ditch, as you and I and Ben expected. I said the first question out of the box, which apparently Mr. Sarro doesn't follow our show because he would have been better prepared. I said the first question out of the box from the panel was going to be, let's understand the limits of your argument. You agree with me that he can't say everything and anything, right, your guy? Yes. And you agree with me, and this was Judge Pillard, and you agree with me that your client is subject to not violate law, right? He's subject to laws. Yes, but he has a First Amendment right. But your guy is not above the law. You would agree with me, right? Right. Okay. And so you also agree with me there are criminal statutes on the books that stop certain things like witness tampering and other misconduct by participants in the trial setting, right? Yes. So is your position that the only thing that a judge in a trial setting can do to gag are things that are already crimes on the books? In other words, nothing short of a crime can be the subject matter of a gag order? Well, and then he couldn't answer it. And she said, well, no, wait. You're here arguing a position. This is the natural extension of that position. Where do you draw the line? We need to balance. You don't seem to be balancing at all. You think the First Amendment vetoes all other rights and administration of justice, and that's not what the case law said. And then Judge Garcia, who's a Biden appointee, no less, he jumped in and said, all the case law that you're relying on actually goes the opposite direction, and which means you're not being credible as an advocate in front of an appellate panel, which is a dangerous, terrible place to be. Then when we saw the lawyer for the Department of Justice get up there, I mean, they gave it to him too. I mean, I've been on hot benches where they give it to both sides, sort of to be equal and balanced and fair and balanced. But they are concerned. You can tell, and I think that it's going to be probably. My guess is Millet is going to, or Millet is going to write the order, but she is concerned, and she used that phrase, we have to come up with a surgical way to balance these competing interests. But they're already, this is my prediction, I'm going to turn it over to you. I think the 4 things are going to come out of this. They're going to find that Judge Chutkan's findings of fact that Donald Trump did these things, that bad things happen and consequences happen when Donald Trump acts this way, that violent rhetoric has real world impact. And they're going to accept that as true, that she did not abuse her discretion in making those findings. They're going to find that a judge, because they're worried about precedent, a trial judge short of crimes can also gag or restrain other conduct of trial participants, lawyers, and defendants. They're going to find that. 3, they're going to find the First Amendment doesn't override all other aspects of the fair administration of justice, especially for a trial participant. And lastly, they're going to put another gag order in place. It may not go just as far as some of the language that's in Chutkan's order. They may send it back to her to tighten up some of that language. But I think that the essence of their order that's going to come out in the next week or so is going to be judges can gag below crimes being committed for prophylactic purposes to avoid bad real world consequences of trial participants, lawyers and judges, even if they're lawyers and clients, even if they're running for the presidency. And here's the parameters they need to follow in order to thread that needle. That's my view. You had a chance to, it was a 2 hours, supposed to be a 40-minute oral argument, 20 minutes aside. It went on for 2 hours. Based on the read of that, I know you've done some appellate work too. What do you think? What's your good faith prediction about what they're struggling with and where they're going to land?
So I actually listened to the full 2 hours of this week. I listened to the full 2 hours of this. I listened to the full 4 hours of the Scott McAfee Willie Floyd bond hearing. I mean, it was just a lot to listen to this week. But I'll tell you, the thing that struck me number one about this was they released the audio. So we got to hear this, and it was in federal court, and the world didn't end. And so I really, really hope that Judge Chutkan will take from this and at least allow the audio from the March trial to come out, because the more we get to hear these things ourselves and see these things ourselves, and there's sunshine and daylight that will actually tell people what is happening, I think the better. And there was no circus, there was no problem. So whatever problem they have, the federal courts have with whether it's cameras in the courtroom, at least audio. Supreme Court allows audio sometimes, at least they did during the pandemic. And I think it makes all the difference in the world. And frankly, people like you and I can actually have access to this information, and we can listen to it for ourselves, and we can interpret it for people that, that's truthful, right? As opposed to relying on Trump or his lawyers, or even frankly, the government or anyone on the other side, their lawyers. Like, I want to make my own decision. I want to hear it for myself, and I want to be able to tell people what I think from my own listening to it. And look, it's much better than having to go down there and have
I just don't think she can under the federal law and federal precedent. But I like that appellate courts post their audio for sure.
Yeah. Well, look, the judicial conference makes the rules, right? And the judicial conference is the one who decides, but I don't see any and they've studied this before, by the way. So this is not a new issue for them. And I really think that maybe she can call upon them, or somebody can get them to do it anyway. Yeah. But back to where we were. This was a hot bench, as they say, right? This was, despite being Biden and Obama appointees, I thought they were equally tough on both sides and equally fair on both sides. Like, they really were listening, and they went much longer than the time allotted, which shows me they're really interested in what people had to say, what the lawyers had to say. And they were really kind of pushing them them to try to get them to, especially the defense, right? The Trump's lawyers. He really took a hard line, right? It was this absolute hard line, and there was no reasonableness. There was no reasonableness in his position. He was very much the one who said, "Look, this is core political speech," right? This was a term that he used, a term of art. This is core political speech, which, in his view, made it much more than just speech, right? It's like this super special protected speech, even more than the First Amendment. And as a result, there's nothing that you can do to limit it, period, full stop. And, I don't think that sat well with the court. I think they said, look, we're asking you for guidance. We're here to set some kind of, make there be a line between what you can do and you can't do. And we have to balance interests, right? There's competing values here and competing interests between protecting free speech and the interest in protecting the right to a fair trial that belongs to both the public, the government, and the defendant, and in protecting people like witnesses from abuse, harassment, and et cetera, or other things. And really what he was saying, what the defense lawyer was saying is, look, if anyone were to threaten somebody or intimidate someone or harass somebody, that's actually a crime. And so if Trump actually crosses that line of threatening, intimidating, and harassing, that's covered by a crime, right? Everything else is speech and is fair game. It's free speech and fair game. And that there's nothing in between, right? There's no kind of ability to have protect the court proceedings. And that's kind of what he was saying. And I don't think the court really bought that, right? They basically said, look, this is not, free speech is not absolute, which we know. And you want to accommodate as much as you can and not obliterate Trump's right to free speech as a candidate. But at the same time, you can't allow him to attack people and put lives in danger, right? And so his refusal to give a line of where that line is, I think really made it so that the court's going to have to draw that line themselves or just adopt what the prosecution said. And, look, one of the things they were talking about was, will attacking the prosecution influence the jury, right? Because a lot of this really falls into, it's about protecting the fair administration of the trial, right? Making sure that nobody's influenced by outside information or outside pressure. You want witnesses to come in and testify truthfully, and that's what one of the major concerns, and that's one of the things that the court has an obligation to do, right? To ensure the fair and orderly administration of justice. And so, one of the questions they were asking was, well, how will attacking the prosecutor influence the jury or the witnesses? Jack Smith has thick skin, and why shouldn't Trump have the right to fight back when others are bringing up his transgressions and these trials during the campaign, right? They go on the debate stage and everybody's attacking him. So he has a right to fight back and call this a political prosecution. He has a right to fight back and say the things that he's going to say. So I do think they're going to give him some leeway, obviously, to do it. But at the same time, they're going to have to figure out how to protect witnesses so that they don't have to be, deal with this whole with the consequences, And one of the things they focused on in this oral argument was a word that Judge Chutkan used in her order, which is to, target. He's not allowed to target certain people. And I think that's a word that's a little too vague and not very precise. And they argued a lot over what does it mean to target. And so I wonder whether that's going to be what they clarify, right, of what does target mean, or are they going to send it back down to Chutkan to ask her to clarify? But I think that's going to be one of the areas where I get the impression that they were a little hung up on what does that word mean. And the other thing that kind of was front and center in the arguments was the defense tried to argue, Trump's lawyers tried to argue that these any threats or anything that happened was a long time ago. It was in 2020, and nothing's happened recently. But, they said, wait a minute. What about if you're coming after me or coming after you right after the indictment? And the response was the woman who was the woman who came forward and was arrested by the FBI because she was made death threats against Tanya Chutkin. And the defense attorney's like, oh, no, she's just an unstable, lives at home, alcoholic. This is not anything. This is not a Trump person. This is just an unstable person. They really tried to move away from that. And really kind of said, look, you can't restrain someone's speech because you're worried about what a third party might do. That's not something you're allowed to do. And so there was a really big discussion about that, right? If Trump says something like, Judge Chutkin's unfair and an animal, and that's it. But then other people go and threaten or harass or even act on those words. How is he responsible for that? And that was a lot. I think a lot was spent talking about that. And look, it's true to a sense. You can't be held responsible for what other people do. But look, he said on CNN, right, during that town hall with Caitlin Collins, he said, my followers listen to me like no one else. He knows what they do. And we have enough evidence in the record of him saying things and the next day, there being actions by others. So I think they're going to put some line in the sand. I think they're going to clarify what target means, and there will be a gag order, but then it goes straight to the Supreme Court, and God only knows what they'll do.
Yeah, I agree with you. I think they're going to issue some sort of gag order. It'll be narrower than the one Chutkin did because it's important. And what we're seeing again, the common theme here on this sort of appeal edition of the midweek of Legal AF is courts struggling to apply law and precedent on the books to an unprecedented former guy who's lashing out, acting out, and testing all of the guardrails that we put around our justice system. The justice system is supposed to be the guardrail, and he continues to challenge it. All right. That's an example of what we do every week, about every hour on the MeidasTouch Network, on a show we call Legal AF. It's a curated podcast set at the intersection of law, politics, and justice. We sit there so you don't have to. And then you can join us on Wednesday nights and Saturday nights at 8 p.m. Eastern Time. And you can pick it up on audio podcasts platforms, wherever you get your audio podcasts from, Google, Spotify, Apple, and all the like. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.